Good morning. Welcome to Buckholder's webinar on construction loans in the shadow of COVID-19. Recently, we did a webcast on mortgage lending in the shadow of COVID-19. Today's webcast is to drill down to the specific issue of construction loans. Obviously, COVID-19 has severely affected the construction industry and construction loans. This is especially true in places which have severe shelter-in-place or stay-at-home decrees, which may stop all construction with a few limited exceptions. Contrast, if you would, a standing or so-called permanent loan where basically nothing needs to be done on the improvement of the property with a construction loan where everything needs to be done on the improvement of the property. Joffrey, do you have some prefatory comments?
Yes, thank you, John. On existing loans, in terms of the status of the market, on existing loans, we've got difficulties now on construction loans with the issues of some municipalities that are no longer doing permit inspections, so it's not possible to get permit inspectors out to check progress, and then also difficulties in getting materials and restrictions in some areas against working on construction at all. The other risks or problems we're having with existing loans are requests for payment deferrals, and in some cases we have an increased risk of complete project abandonment. As far as new loans, we're running into a number of issues. The question of what the rates should be and what yields will be required by investors and what the risk levels are difficult to tell. It's very difficult to tell what the value of a completed project would be at the end of construction, since we don't have comparables in this market yet, and we don't know where the market's going to go. It's hard to tell what lease values will be, what things we'll actually be able to lease for when and if the project is completed. And then the earlier mentioned permit inspection issues. And then lastly, we have the issue of takeout financing. We don't know what financing will be available or what buyers will be available to pay off our construction loans when they're completed. And aside from all that, everything is just fine. Mike, would you like to cover the locations of projects?
Yes, I'd be glad to. Given that we are facing very severe shelter-in-place or stay-at-home rules, both in various local jurisdictions, particularly almost every major urban area, and across entire states, such as California, you may find that some or all construction is limited by location. So you need to check with the jurisdictions you're working in to see if, in fact, you can go forward with construction. Jason, do you want to talk for a second about the related issue of how there may be restrictions based on type of construction?
Yes, thank you, Mike. As previously mentioned, figuring out what laws, regulations, and orders must be considered with respect to the feasibility of an ongoing construction project depends on a local, county, and statewide basis search that must be conducted. Certain laws and orders I've seen come down recently have stopped all construction with few exceptions. If you're building something for affordable housing or sewage treatment, or you're building a hospital, those types of construction projects have been allowed to continue while others have stopped. But this does not ring true in every city, county, or jurisdiction in California or the country for that matter. However, you need to just make sure that you consult all of your local, county, and statewide government regulators, et cetera, to determine where you need to go to determine whether you can proceed and what issues you're going to have to deal with if you can't. And as we go through this presentation, we will provide you with some comments and recommendations. Joffrey, can you provide us with some thoughts on the stage of construction and how that may be affected by COVID-19?
Yes, Jason, thank you. In the analysis of projects in process or projects you're working on, critical to that analysis will be looking at what stage your construction is commenced. So if you're, for example, have just poured a foundation, or if you're installing final fixtures, all of that has to be taken into account as you analyze these. John, would you talk about the inspection issues?
Certainly. You have here a couple of issues. First, obviously, it's going to vary depending on your geographic locale. But one of the first things you're going to encounter is government inspections. For example, do you need to get the building department to approve your electrical installation? Do you need, for example, to get a certificate of occupancy, assuming you're getting close to the end of building an apartment building, so that your loan can shift from a construction loan to a mini perm or something like that? What about the private instructions for a construction draw? Some of the inspectors are relying upon photographs. In other words, if the general contractor can go out and take a number of good photographs so that they can look at the photographs that have a high enough resolution and see, yes, the concrete has been poured. I can authorize the draw for the concrete because I can see for the photographs it is there. But these are going to be two critical considerations on whether or not your project can move forward. Jason, can you tell us about parties with whom the lender will need to communicate?
Yes. If the COVID-19 restrictions begin to affect the progress of a construction project and the loan secured by, there is a large universe of people that the construction lender is going to have to communicate with. We want to point out before I go through this list that it is very important that the lender does not cross the line from its traditional role as a money lender and turn into an active participant in the transaction. Once you become an active participant in the transaction, you lose a lot of the protections that are provided to lenders under the law. For example, there's generally no duty of care by a lender to a borrower, and there's no duty of care by a lender to a non-customer. However, once the lender becomes an active participant in the construction project, duties will arise under the law, and it opens up the lender to liability. This is a good point, and I'll mention it a few times, is no good deed goes unpunished. You do not want to help too much, but getting more to point out some of the parties that you're going to have to deal with. There's obviously the borrower, what's going on with the specific project, what they're trying to do with it. You have to keep the guarantors apprised of what's going on. You want to make sure that the guarantor receives the same information as the borrower, because you definitely don't want to do anything that would prejudice your rights against collection of the guarantor, excuse me. There are numerous defenses that guarantors can raise, and we've done a webinar on that in the past. And if you keep your guarantors as informed as the borrower, you're not going to have as likely a problem as if you did not. There may be loan participants based upon the size of the construction project. You want to make sure they're well informed of what's going on and any considerations you may be thinking about making. What about takeout lenders? The project probably had a plan, hopefully, to get takeout financing. You want to keep them apprised so you can keep them on board. There's obviously those people actually involved in the day-to-day on the construction project. General contractors, subcontractors, material suppliers. There's hopefully an escrow agent assisting with the disbursements under the construction loan. You obviously have to keep your title insurer well advised of what's going on and on notice of everything. One of the big ticket items that happens when a construction loan starts to go south is the issue of mechanics liens, and you want to make sure you've given your title insurer all the notice that you can about anything, because you're going to want coverage under your policy if any mechanics liens issues arise. Also, if there are junior liens on the project, you want to keep them informed, because if you take any action that may be considered adverse to them, you could lose lien priority. And I believe Mike's going to talk about that later on in this presentation. Also, in this age of news frenzy, where you can't turn on a news channel without getting a full blast of COVID-19 and how it's causing numerous damage to the entire universe, you may need to be careful that news media could be involved depending on the decisions you make. A distressed borrower may be a perfect topic for a news presentation on what's going on with COVID-19, and you don't want to be the lender that is on TV getting talked about negatively regarding how you deal with a construction loan in distress. You may have to deal with regulators, borrower complaints, etc. And you need to keep the loan servicer apprised of what's going on as well. But when you first begin talking to the borrower regarding taking some action if the construction loan is beginning to have some problems, you're going to want to have a protocol agreement, and Joffrey is going to talk to you about that.
Thanks, Jason. The big picture on this is that when people start talking about modifications, people being loan servicers or lenders start talking about modifying a loan, there may be some discussions beginning, and then there may be some emails going back and forth saying, we think we can do this, or we'll consider doing that. And then if an agreement isn't reached, then someone might take those emails or those other communications and allege that they had some kind of a promise or an agreement. So many loan servicers and lenders take the approach that before they start discussing anything, they get a pre-workout or protocol agreement executed by all the parties that basically says that there's a discussion occurring, but that nothing is an agreement to change or modify the loan until all parties have entered into that modification agreement. And there's a list here of the different parties that may be involved. Another thing in putting together your protocol or pre-workout agreements is discuss with qualified counsel the issue of whether or not you could insert a judicial reference or arbitration agreement, and also whether or not you're able to put lien, or excuse me, not lien releases, but release of claims within that protocol agreement. And then, Mike, could you discuss the issues of projects potentially losing value?
Certainly. I mean, obviously, in the current economic situation we're facing with the entire economy going through very significant shrinkage, that is spilling over into real estate, both residential and commercial, and seeming to impact real estate values. We've all seen stories about this in the media the last few weeks. And it's important, as you're working on this type of project or considering this type of project, to take that into account and make sure you're getting accurate valuations, both from a perspective of making sure you have the right protections in your documentation, but also as a business matter, just to make sure your deal makes sense. So a few thoughts on that is consider the type of property, a shopping mall versus an apartment building. Shopping malls, obviously, retail traffic is shrunk by huge percentages, creates a problem. Apartment buildings have more staying power because you can't evict people, but at the same time, you have in place various provisions regarding, because of the inability to evict, you may find tenants being able to effectively get forbearance on rent payments, or be required to get forbearance on rent payments depending on your jurisdiction, which affects short-term viability of the project and may in the long term affect it when you consider what happens when we come out of this situation and those tenants have to catch up on their rents. Another important question is the appraisal post the start of this crisis. It may be, particularly in certain types of commercial businesses, that a pre-COVID appraisal just is not accurately reflecting where we are now. And so you want to look and see if the appraiser specifically considered the potential adverse impact of COVID on the value of the property, but being careful that they distinguish between likely short-term and long-term consequences and how that fits into your particular program. So next, let's discuss determining whether the project, let's move on from this and go on to our next topic. Excuse me.
Okay. Thanks, Meg. Also, a suggestion, this is John, that when you do get an appraisal made, have it made by or for the benefit of your attorney, so that the appraisal is going to be protected by the attorney work product privilege, because if you get the appraisal, there is a substantial risk that the appraisal may be inaccurate and it may be thrown back in your face at some later date. But if you have the appraisal obtained by your attorney, then you should be able to protect it through the attorney work product privilege. Let's focus on advances and whether or not your loan is in a condition of default. Before you do anything, you need to carefully review your loan documents with counsel to determine whether or not you have any defaults. Many loan documents contain provisions for what I call automatic defaults. In other words, if you don't make the mortgage payment by a certain day of the month, for example, the 10th day of the month, it's automatically deemed a default. If you do not provide a financial statement every quarter, it's automatically deemed a default. Other loan documents provide that the failure to do those things is not a default unless the lender declares them, and then other loan documents provide for some automatic defaults and other defaults that need to be declared. What is the significance of this? The principal significance of this is that if you do have a default and you do make an advance, there is a significant risk that your advance may be considered optional, and if it is an optional advance, it may well lose priority to any subordinate lien on the property. So you need to find out early on, do you have any automatic provisions which place the borrower in default so that your further advances are optional and not obligatory and lose priority. Jason, what about insurance coverage for COVID-19?
With respect to any major construction project, the lender should make sure that there's adequate insurance both on its own behalf and on behalf of its borrower. There are major issues in this country right now regarding what is and what is not covered based on the damages that are being caused by COVID-19. For example, and without limitation, as a result of this pandemic, there have been mandatory closures of most places of business. Concerts and sports have been shut down for the first time in my lifetime. People are not able to use business property. They're not able to get the service they require, supply chain disruptions, etc. There is an incredible amount of income loss that's been occurring due to the existence of COVID-19. And this also affects the construction industry and the construction lending industry because the projects for which the construction is ongoing is forced to be stopped. That may adversely affect the ability to get payments and then put you in the position where you need to figure out what mitigation tactics you're going to take on. But there are some insurance coverage that will provide indemnity in these situations. Having broad form coverage for property insurance, business interruption, and business income could be very beneficial during this time. For the construction lender who normally is allowed to continue on with the project and receive payments, that may assist them buying through the actual lender if they're able to get business interruption insurance and through the general contractors and a lot of other things that prevent the recording of mechanics liens. For example, if the general contractor has business interruption insurance and because of the fact of COVID-19, they're not able to operate their business, they may be able to get coverage. And if they're able to continue to get payments that way, that may be a basis to avoid mechanics liens. However, please be advised that the COVID-19 pandemic has been the subject of many denials of claims by insurers, and it is the subject of numerous legislative efforts in progress to try and legislatively require the insurance companies to pay claims based on COVID-19 when they otherwise wouldn't have been covered in the first place. Most policies include exclusions for damages that are caused by disease or many other things, but it's something that's out there. It's something that should be considered, and in the future or on any new construction loans, if any of those are going to be made during this time period, that needs to be considered. Also, there may be lawsuits that come out of this pandemic based on the whole construction loan project, and if the borrowers, guarantors, construction lender, the general contractors, et cetera, have other types of insurance, commercial general liability, D&O, et cetera, there may be a way to mitigate against the loss. But insurance cannot be overlooked. We'll also talk about title insurance later on in this presentation, which is also critical for this type of situation. and also making sure it's not on this list, but EPLI insurance may assist with claims by employees that arise during this pandemic because they're going to make claims they had to work too long, et cetera. There may be coverage for that. But perhaps the most important type of insurance during a construction lending situation is your title insurance policy. And Mike, will you talk to us a little bit about title insurance and recordation?
Certainly. There are a lot of practical issues that have resulted from the COVID virus in terms of title insurance and recordation. First one is your title insurer or your title agent closer open and operating? And if they are, how fast are they going? We're seeing situations where the title insurer, the title agent are open, but they are understaffed or working everything via email as opposed to other forms, having people come in and sign closing documents and such. And this is slowing things down, and it may be slowing down how quickly they will record things and how quickly they're willing to issue the various preliminary title documents you're looking for as you work on your transaction. You need to be aware of that, and you also need to be aware that they may prioritize who they work with, favoring their existing customers or larger customers first. So you need to get into the queue quickly with them to make sure your deal can move forward in a manner that meets the requirements of your documents and other conditions you have. And then, of course, there's the question even beyond the title insurers, is the county recorder's office open and operating? Some of them have closed temporarily. Many of them are on short staff or are trying to work through remote conditions. This is very difficult. It is slowing down recordings in many places. It creates a number of issues for you, such as the timing of your disbursements relative to recording. You can't do as happens in many jurisdictions normally. You get a confirmation from the title insurer that they've walked something over to the county recorder or electronically transmitted it, and it's recorded or in the recording queue to be recorded that day. You can't rely on that right now in most jurisdictions, so you've got to figure out how to address that. You may have to look in terms of things like gap coverage, but we want to point out that while gap coverage may be available, title insurers are putting in place stronger indemnity requirements from their customers to get gap insurance and other conditions because of the exposure they face. These are all hurdles you can overcome, but you should start looking at them immediately as you start into the deal, because you don't want to get down the pathway and discover that what's normally a routine title and recording process has entirely slowed up your transaction or caused the structure of your transaction just not to be feasible. John, could you speak for a minute, start speaking about the issues related to when a borrower requests a loan modification agreement?
Certainly, Mike. As I previously indicated, the first thing you obviously need to do is carefully review your loan documents with your lawyer to figure out exactly what the deal is with the borrower. Secondly, you need to get that protocol agreement, which Joffrey talked about, with the relevant parties. Third, you need to get current financial statements from the borrower and all guarantors, and you need to take a realistic look. In other words, is your borrower or guarantor in the retail business? Are they in the restaurant business? Are they in a business that is materially adversely impacted by COVID-19 or one which is not materially impacted? You should also conduct a litigation search on the borrower and all guarantors. Finally, as previously discussed, you need to have your attorney obtain a current appraisal on the property. You also should determine if the request for the loan modification was caused by COVID-19 as opposed to it was caused by simply a loan maturity or some other default unconnected with COVID-19. If you are dealing with a developer who has more than one project, you need to look carefully at the other projects, because other projects can draw upon assets and income similarly with respect to guarantors. You also need to look at what disaster relief programs, if any, the borrowers and the guarantors may qualify for. You may want to give some consideration in getting an assignment of that. I saw a case out of West Virginia the other day where a bank offset a bank account where the customer had deposited their relief money, and the court ruled that was unconstitutional and ordered the bank to restore the money immediately. Jason, what are some of the lender alternatives in the event of a default?
Well, first of all, the events of default that will likely occur could be the recordation of a mechanics lien, the delivery of a stop payment notice, failure to pay. When the event of default comes, the lender must immediately notify the borrower and guarantor in writing and request that they cure. This goes back to John's discussion earlier of optional and obligatory advances. You need to make sure that if there is a default under your loan documents, that you take action upon them or point out whether they are not going to be enforced, because later on down the line, you don't want to find out that somehow any of the advances that you gave did not have a first lien position or the required lien position on the property. Depending on the nature of the default, you'll need to inform your title insurer, the escrow agent, and or the surety on the project. Under standard title insurance policies, you're required to provide notice of any adverse situation that you discover. Obviously, the potential or the existence of a mechanics lien would be one of them. If you don't provide timely notice, the insurer may use that as a basis to deny your claim. Therefore, you need to move forward expeditiously. If there is an event of default, you want to see if the borrowers or guarantors can contribute some more money to the project. If they are willing to do so, that could take off the load off the lender and also allow for more of a loan to value ratio that may have the lender willing to consider it. If the lender is concerned and really wants to get out, you can discuss the borrower obtaining additional financing to take you out, and see if there's also additional investors that could invest in the project, whether or not the construction project can be reduced or done in parts. And even as one of a more of a last-ditch effort, whether the borrower can sell the property as is in its incomplete condition and thereby get the lender paid off. Depending on the circumstances of the lender and its assets and what's going on with its portfolio, the lender may want to consider whether it can sell the loan at an acceptable discount, thereby getting out of having to deal with any issues and making a recovery right there. There's also issues that could arise if there's multiple beneficiaries. You're going to want to make sure that they're all on notice of what's going on and what decisions will be made. And if it is any type of situation where the majority gets to make the decisions for the minority owners, then you give the appropriate notices so that you cannot have any future claims brought by the minority beneficiaries against you. Mike, in these situations, can you let us know your thoughts on whether a notice of default and election to sell under deed of trust should be recorded?
Certainly. This is actually quite a serious issue. There are some very strong reasons why you would want to do this, but at the same time, you may find the borrower resisting this to some degree. Key points are that if the borrower doesn't want to record a notice of default, you run the risk that the borrower may go into bankruptcy, insolvency during this time period. The problem being that if that happens, the lender won't be able to record a notice of default until it obtains relief from the automatic stay, and may have some priority issues because everyone else is going to be rushing in at the same time to the court to get such relief and stay. Therefore, we recommend that you record a notice of default when you start into this type of negotiation for a modification, because particularly for a forbearance agreement, to avoid the risk of bankruptcy. If a borrower is asking you for a modification, particularly a forbearance modification, the odds are the borrower is in potentially very severe economic distress and could file bankruptcy any time, even if for them it's just a defensive measure in regard to other creditors or you. So we recommend that you do so and move forward. If the borrower resists, try to work through that with them and explain what you're doing. And in fact, if they resist a lot, you might want to consider whether that is a sign that you actually need to do it. Let's see. Next, we'd like to talk briefly about how the modification agreement should expressly provide that all the terms that are not being modified remain in full force and effect. Joffrey, can you talk about that for a second?
Yeah, just as an introduction to that, now with the market going the way it's most likely going to go, and with an increased number of defaults and other issues, we'll probably see a lot more situations where both borrowers and lenders or loan servicers feel that there's a benefit by entering into some kind of a modification agreement. And modification agreements have a lot of other aspects to them. So as to those specific aspects that have to be considered, Mike, could you cover some of that?
Sure. I first want to go to the third bullet point, say that, of course, what you want to do is have a modification agreement, not a rescission, because if you rescind and are creating essentially a new agreement, you may have priority issues, may have issues about the impact of prior actions, and things like that. So a modification is, generally speaking, a situation where the details of a contract, leaving its general purposes undisturbed in a modification agreement, that constitutes a modification rather than a rescission. And to be more specific, a modification agreement legally is an agreement to an existing contract whereby the parties alter some of their obligations without deleting any of the elements that are considered essential to the validity of the original contract. What that means is there are certain terms that are essential to have formed a valid contract. The purpose of the contract, the monetary terms, the time terms, the parties, terms like that. You may be modifying some of those, such as the time for payments. You may be modifying payment amounts. You may be modifying interest amounts. Those are all essential terms of a contract. You can modify them, but you need to be sure that in that process you don't remove any of them, or suddenly you don't have a valid modification agreement, which obviously affects the modification agreement, but may also impact the original agreement. So those are some practical legal considerations to take into place as you're drafting the agreement. Make sure when you read it that your original agreement is entirely in place, except for these specific terms you are trying to modify. Next, we want to talk about standard provisions to be considered in drafting a modification agreement. And Jason, can you take us through that?
Yes. Before I go into some of the more standard or more controversial items, I just want to point out that during good times, not many modifications are necessarily needed. If they are, they're normally fairly friendly, and they're not given much scrutiny. However, now in the age of COVID-19, any modification agreement provided to a borrower is going to be closely scrutinized, both during the negotiation and in the times of necessity to enforce the agreement. So in that vein, you definitely need to try and make sure you're not viewed as overreaching or taking advantage of a borrower who is in a precarious position, because you may be subject to claims of unconscionability, or that you breached the implied covenant of good faith and fair dealing. So that definitely needs to be kept in mind. One of the primary considerations to be adding an ADR provision. A lot of people like to add a mediation provision before legal action could be filed. That's something to be considered. Choice of venue. Where are you going to bring this action if anything happens to go wrong after the modification is entered into? Statute of limitations. You can contractually shorten a statute of limitations. However, this is one of the items you may want to be wary of at this time, due to the fact that it may be looked at negatively. You can also put limits on recoverable damages. It's not something that's done often, but we found case law throughout the country that supports this. Releases. We do recommend that in your modification agreement, you do put in a release in connection with a construction loan. There's adequate consideration for it. It cleans up any issues that occurred pre-modification, and it is just something we highly recommend. Make sure the borrower admits their defaults, that they have no defenses to the obligation, that they acknowledge that the balance is unquestionably owed, and if you want to increase the interest rate, just do so carefully so that you can hopefully avoid any claims of unconscionability. You also want to make sure that the granting of a loan modification is not considered by the borrower to be a guarantee of further modifications. Therefore, you want to put in an express provision which specifically states that it's not. Mike, what do you think about detailed affirmations in a loan mod?
Thanks, Jason. one of the issues you have to face is that you and the borrower are obviously modifying the loan because of either the borrower's economic conditions or some other problems with the loan, which may in fact be breaches of the loan or default or qualify as defaults under the loan, or just be indications of problems to come. And when you're doing a modification agreement, you want to make sure you address those issues, both the ones you're aware of and the ones you're not. You don't want to go into a modification agreement if the borrower, without knowing that the borrower is aware of facts that may constitute a breach or that may put you on notice of other particular problems that will not only from a business perspective affect what you're asking for, but from a legal perspective, you don't ever want to be seen as having waived or acknowledged any problem and not be working on a resolution or not be reserving your rights to seek a resolution of the problem later. Therefore, we recommend that in the modification agreement, the borrower should provide detailed affirmations about the loan. That's things like the principal amount owed, the current interest rate, other key terms of that type, the timing provisions, that kind of thing, and that there are no defenses to the loan, that no breaches by the lender, and nothing which affects title, such as lien priority issues, that the borrower is aware of, or any facts the borrower is aware of that would lead to those particular types of problems. You also want affirmations that borrowers had the opportunity to consult with counsel, because you don't want them coming back later and claiming that they were in an unfair, disadvantageous negotiating position with you, and that they had sufficient time to make a decision on the modification. Now, you may have to move on a modification fairly quickly, and if you do, that provision about sufficient time should acknowledge that the parties recognize that for some reason this had to be done quickly, but the borrower acknowledges that given those circumstances, they had sufficient time to speak to outside counsel and get advice if they so chose. Now, John, could we move on and talk about fees, charges, and deposits for a modification if that's desired or needed?
Certainly, Mike. One of the things that the lender is going to face when they receive a request for a modification is the fact that they are going to be expending a substantial amount of time and money to explore the modification, with the risk that the borrower or the guarantor may not agree to the modification as proposed. Ideally, you have a situation where your original loan documents provide that a reasonable deposit may be required as part of any request for a modification. If you don't have that, you're arguably on thin ice, as it were. But to take a look at what time is going to take a look at what your anticipated expenses are. Obviously, you may have legal expenses. You may have expenses for a endorsement to your loan policy of title insurance, and you don't want to get too far down the road spending your time and money exploring the potential for a modification, only be told by the borrower or a guarantor that they won't do it, and so suddenly you find yourself, deeper in the hole. So think about a fee or charge or deposit up front and explain to your borrower and the guarantors that the reason that you are requesting it is that you're going to be spending time and money, and you're also going to be facing a potentially increased risk to your position, and this is to compensate you for the time and money and the increased risk. Jason, what about specific issues related to construction loans during the COVID-19 pandemic?
There are a plethora of specific issues, and we're going to go through many of them now. We talked earlier about no inspectors. We know some lenders who are now mothballing projects, stopping the financing on the agreement that they'll do it later once they're able to go forward. You want to be careful of breach of the construction loan agreement. Whatever you're going to do, make sure it's documented and reviewed by qualified counsel. You definitely want to avoid breach of the implied covenant of faith and fair dealing. Make sure that you're forthright with your borrower, guarantor, and all interested parties. As I mentioned earlier, the lender needs to avoid going beyond the scope of a traditional lender of money. This may create duties, including fiduciary duties. These are duties you don't want. You don't want to be an active participant. Once you become an active participant, that's when all sorts of potential liability is imposed upon the lender, which we want to avoid by providing you with these recommendations. The loan funds could be improperly dispersed. Those are primarily dealt with optional advances, determination of loan disbursement. There are issues of whether or not they were satisfied by the borrower, the conditions to receive it, or if the borrower is in breach of the loan agreement. Again, you should consider having this reviewed with qualified counsel to make sure you're aware of the risks that go with either making the disbursement or declining to. The borrower may claim that they need you to extend the date of completion and thereby extend the date of the loan. Whether you're going to do that or allow it or consent to it could create issues down the road. Again, you don't want the lender to take control of the borrower because no good deed goes unpunished. You have to continue to separate the role of lender from that of the borrower because some of the things that could happen is based on the actions that are taken by the lender, it may be construed later in a court of law that there was some sort of excuse for performance. And John's going to talk to you a little bit about that right now. John?
Thank you, Jason. There's a variety of excuses which may come up dealing with COVID-19. Obviously, you have so-called force majeure, which Jason will talk about a little bit. But, you need to anticipate that sort of everyone involved, from the lender to the takeout lender, the borrower to the guarantor, general contractor, subcontractor, material supplier, buyer, seller, and tenants, will all be thinking about, is my performance excused in some fact? Next thing you need to look at is the actual impact of COVID-19 on construction. If you're fortunate the project is not started yet, you're just negotiating it, and you may be able to stop it and put it on hold. On the other hand, it may be a situation where the start of construction is simply delayed or it's slowed down, but definitely you need to anticipate that the cost of construction, at least in the near term, may be increased, and you may face a situation where the construction is actually stopped. You also have a situation where, depending particularly on the type of project, the value may be materially decreased. You also have the need to preserve the value of the improvements. In other words, if work is stopped on the project, what steps have you taken to weatherize the project so the project does not deteriorate? What about insurance coverage? Oftentimes, insurance coverage will lapse if you have abandoned the project for a period of time, so you need to take a careful look at whether or not your insurance coverage needs to be tweaked. Jason, what are some of the grounds for non-performance?
There's force majeure, which could come across as a result of government orders and other forced stoppages, material adverse changes that prevent performance, the doctrine of impossibility. If you're unable to do something, that may give you a basis for an excuse. Obviously, we discussed earlier the emergency orders. There's also the potential for the decline in value of the project, and clearly the failure to perform on time if they're not even allowed to show up to the construction project to begin with. We discussed earlier some of the lender's responses for non-performance could be a loan modification. This could allow the borrower some breathing room, get the lender a release, and hopefully allow for the project to continue on slightly different and or more favorable terms. The lender could also do a forbearance agreement. There's consideration provided in doing so, and the lender could also get a release, gives the borrower some breathing room, and may allow for the project to continue at a later date. All other alternatives should be considered. We went through a laundry list earlier, so I won't go through that again now. The lender also needs to consider its reputational injury. Right now, COVID-19 is on the news every day, all day. Newscasters are constantly looking to find some new story, and the lender who is being allegedly unfair to its borrower could surely be a catchy title, and you don't want to be on this week's news. Joffrey, what about getting consents in a loan mod and or forbearance situation?
Well, thank you, Jason. In this situation, we're talking about guarantors, and obviously in this type of a market that we may be entering into and with potential defaults, we want the guarantees from guarantors more than ever. This is when we may really need them. So we don't want to lose our guarantees. If you modify or change a loan without permission of the guarantors, then it puts the guarantors in a position where they can say they agreed to guarantee the original loan, they didn't agree to guarantee the modified loan. So it would be a matter of getting the permission and approval and agreement of all guarantors to any modified loan terms. And then also there could be some discussion as to whether the guarantors should even be involved in the modification negotiations from the start. So with that, John, would you talk about the issue of title, the status of title?
Sure. In a number of states, California being a good example, it is very difficult, if not impossible, to determine the condition of title because you cannot rely upon a preliminary report or a policy of title insurance to provide that information. Alternatives are to get a litigation guarantee or a chain of title guarantee. However, even there, you're going to run into a gap between the date of the guarantee and the date of your transaction. You have a situation where you may have made the loan yesterday to Mr. Smith, and after the loan was made, he conveyed the property to Smith LLC, or he conveyed the property to his brother, or he took on a partner. So you may have a situation where the collateral you had yesterday when you made the loan is not the collateral you have today when you're asked to modify it, and so you need to make clear to the borrower when you receive the request for a modification agreement that one of the lender's requirements would be that the status of the title of the property must be as good, if not better, as it was when the loan was originally made. Mike, what are some of the steps you can take to avoid the loss of priority of the current mortgage?
As we discussed earlier, this is Jason. You need to be careful when you are modifying a mortgage loan due to the fact that there may be junior lien holders behind you. When you modify a mortgage when there are junior lien holders behind you, you take the risk that there could be either a complete loss of priority or the loss of priority to the extent that the junior lien holders were prejudiced. The question is, how do you know who has a junior lien interest in the property? You may have made the loan with the requirement that it be recorded as a first lien. So it was recorded as a first lien. Your records reflect that there's only your loan on it. But as John mentioned, borrowers do things throughout the course of a construction project. Project could have originally been in the name of John Smith, and then it was conveyed to XYZ Corp. But XYZ Corp has a judgment against it, and now the judgment lien is now a junior lien on your property, and you make a modification without considering it, or you find out that the borrower got another loan secured by the project, and they recorded a deed of trust, and you didn't know about it. Either situation provides the risk that there may be issues regarding priority. Generally, you want to try and get a modification endorsement. Thereby, you get your title insurer involved, and you get an addition to your insurance policy that protects you from any claims by junior lien holders. But these are things that you definitely need to consider, and John's going to go a little more into that on why you want to get title insurance coverage for the modified mortgage. John?
Thanks, Jason. First, you need to anticipate that your title insurer will take the position that if there is a modification of the loan without a new endorsement, that your title insurance coverage has terminated. Secondly, you need to anticipate that your title insurer will take the position that the loan policy of title insurance does not extend to or cover the modified mortgage. Third, you need to anticipate that making a request for and hopefully obtaining a modification endorsement to your original loan policy of title insurance. Next, you need to anticipate that the title company may require an affidavit from either you or the borrower relative to the condition of title, and you need to look very carefully at that because otherwise you as the lender may be converting yourself into your own title insurer. Finally, because of the delays in recording, you may have a gap between the point where you think you're closing the loan and the point where the loan is actually closed and the documents are recorded. Now, in much of the western United States, people are not familiar with gap between the closing and the recordation. In much of the eastern United States, that is not an uncommon issue. So you need to check with your title company to determine, A, will there be a gap, and if so, is title insurance available for gap coverage. Next, if you do a modification, what you then need to do is to have the title company record a notice of modification. After you've recorded the notice of modification, you need to do a date down to determine whether there is anything that shows up in the record between the, I should say before the date that your notice of modification was recorded. Jason, what are some alternatives to a loan modification agreement?
One item is an additional loan guarantee. Get another person or entity that has significant assets that can guarantee that the loan will be repaid. You can get additional security from the borrower or the guarantors, another deed of trust on some other unencumbered property or in a sufficient lien position to provide you with some comfort. There's always a mini perm by the construction lender to provide some additional financing. The project could be sold. We mentioned that earlier. Bridge financing. You can get a participant into your loan. One that's not as palatable would be litigation or deal with bankruptcy. There are things called involuntary bankruptcies. And if you feel that you qualify to put your borrower into an involuntary bankruptcy, there may be some benefits to that. One of the things that arises during the construction loan project when things go south are stop payment notices and mechanics liens. And John, if you could jump in on that.
Sure, Jason. These are two of the construction lenders' nightmares. In many states, California is a good example. Mechanics liens exist without a piece of paper being recorded in the recorder's office. The lien exists simply as a result of labor or materials having been furnished to the construction project, and that those labor or materials are visible. So one of the first things you want to do is to find out what caused the problem. Is it COVID-related? For example, do you have a hospitality project, a hotel or a restaurant, or retail, or is it not COVID-related? You need to get out immediate demands to everyone, borrower, guarantors, escrow agent, title insurer. You need to attempt to determine who is responsible, and then you need to ask yourself, how do you get construction, completed? Also, if you have a situation where you do not get an affirmative response from one or more of the people you put a demand upon, you need to consider getting a tolling agreement so you don't need to file suit against them today, but you can defer that until tomorrow. If you get a bonded stop notice, you then have the problem, do you need to withhold the funds based upon the bonded stop notice, and that's probably a situation which you have to do. On the other hand, if the stop notice is not bonded, it then becomes a discretionary matter. You do not need to withhold the money, even though it is a good idea to withhold the money when you get a stop notice, whether bonded or unbonded. You also need to keep in mind that the lender has potential liability for failure to withhold funds, and you also need to keep in mind that under the so-called Chameleon Court versus Imperial Bank case, that if you are facing a stop notice, you're potentially looking at a clawback of your interest points and fees, though that the Chameleon case was distinguished by the Steiny case. Unfortunately, the Steiny case ended up getting depublished. Jason, what can you do about tendering a complaint to your title insurer when you're sued by a mechanics lien claimant?
Your first step should be making a claim against your title insurer. Tender early and get that out there because there are certain time limits within which a title insurer or any insurer is required to respond to the claim. Under California, we have what's called the California Fair Claims Settlement Practices Regulations. It provides time frames within which an insurer must acknowledge receipt of your claim and a time limit within which an insurer must respond to your claim with a coverage opinion and further provisions that deal with if the insurance company needs more time. But this needs to be done early. It needs to be done right upon receipt of notice. You don't want to give your insurance company any wiggle room. You also can't forget that you have claims against your escrow agent. If your escrow instructions were properly drafted, there would be liability against your escrow agent for not recording your deed of trust in the required lien position. John and I review and revise lenders' escrow instructions regularly. We found that even some national banks use language that is inappropriate and would not really provide any claim against their escrow agent in this situation. So you should have your escrow instructions reviewed by qualified counsel. It's not something for the back room. When things go south, they're critical. As John mentioned, should you have a tolling agreement, sometimes your title insurance company will accept the claim, which is a good thing sometimes and a bad thing other times, but that's for another presentation. But the statute of limitations is still clicking against the escrow agent. So when the title insurer accepts your claim, you should consider a tolling agreement with your escrow agent to preserve your claims if the title insurer ultimately does not resolve the claim. When you get a defense paid for by the insurance company, you need to make sure that they are monitored at all times, preferably by your coverage counsel. The title retained counsels are paid by the title insurer, not you. Their true loyalties are supposed to be to you, but practical situations arise and they really are working for the benefit of the title insurer. So just be careful and be vigilant. As we discussed earlier, there are claims against your escrow agent. There are claims against your title insurer. You should have a tolling agreement and you need to monitor what they're doing. Mike, can you talk to us about a consensual workout of a defaulted loan?
Certainly. Ideally, you can work this out in a consensual way. In a minute, Jason will discuss the ways you can handle it if that doesn't occur and you have to work it from another perspective. But in terms of consensually working out a defaulted loan, something we want to say again that's already been touched on is getting a modification endorsement, if you can, for the loan policy of title insurance. This is a really big issue. That's why we're mentioning it so much. It's very important that you try to do that. It's important you also include all necessary parties. Consider the inclusion of any guarantors whose rights might be affected or who because of that might claim they don't have to honor the guarantee or that you didn't give them notice of a change in the loan. Spouses in a community property state, if the property is in fact secured and is owned by an individual, you've got that kind of issue. You've got co-borrowers, you've got to make sure to get notice. You may have to consider getting notice to junior lien holders if there is any risk of what we discussed earlier, that is the partial loss or total loss of priority, particularly if the title insurer won't issue a modification endorsement. And don't forget that oftentimes in bad economic conditions, as property values decrease, junior lien holders often don't want a senior lien holder to start doing foreclosure. It's not economically beneficial for them, so they may be very willing to talk with you about consenting to a modification or acknowledging it. And then I also wanted to remind you, of course, that you need to think about representations and warranties regarding proper corporate authority for the borrower to sign the modification agreement, consistent with what was in the original loan agreement, and also representations and warranties from them as to whether or not their internal policies and procedures require a board of directors certification, and getting such a certification approval if in fact that is needed for the transaction. Of course, all of this may not work. The borrower may try to disrupt any workout you've agreed to by certain tactics through litigation, which you may want to consider trying to build into your agreement ways to avoid that or limit the borrower's rights. And that can be hard to do, but it's definitely worth focusing on. And then bankruptcy, as we discussed earlier, borrowers can file bankruptcy and cause problems if you don't have a notice of default recorded. That again is why we've been recommending that as a step. And now, Jason, do you want to go on and talk about a dispute resolution regarding loan defaults when you're not getting cooperation from the borrower?
Yes, depending on what your loan documents have, will vary on what you're going to do when you try and see if you can resolve this. If you've been to any of our other presentations, you know jury waivers are unenforceable in California, but there are other items you may have in your loan documents that you can utilize to keep this matter away from the jury. and still get it toward a resolution where hopefully the audience will be more favorable. If you have a mediation requirement in your loan docs, you should utilize those. It is a good way to resolve things before you have to spend a lot of attorney's fees. If you have an arbitration provision, you just need to make sure it's enforceable. There are a lot of cases that come out here all the time regarding arbitration provisions that are considered unconscionable and unenforceable. Judicial reference in your loan docs can help. It gets you into a more of a speedy situation in which you do have a judge. And there's also where you're going to litigate state or federal court. These are questions to be considered as you move on. John, what about a deed in lieu of foreclosure?
Couple of three things here, Jason. First, you have a situation where in the event you take a true deed in lieu of foreclosure, in other words, borrower conveys to lender, you then end up taking the property subject to all the problems on it. So you would, for example, lose priority on your mechanics lien. Sometimes you have a situation where the borrower, without asking you, will simply deed the property to the lender and try to walk away from it. If that's the case, you immediately need to record a rejection. Therefore, the deed in lieu of foreclosure, the so-called true deed in lieu of foreclosure, while superficially attractive, carries with it a number of problems. Accordingly, you should consider a modified deed in lieu of foreclosure, where the borrower deeds the property to a third-party entity which is affiliated with the lender. You get a non-merger endorsement to the loan policy of title insurance. Therefore, the borrower is out of the property, but the lien remains so that you can foreclose if needed. Jason, what about foreclosure of a construction loan deed of trust?
If all else fails and you can't resolve this informally, we recommend that you assign the defaulted loan to a special purpose entity. Then you can consider whether you want to do a non-judicial foreclosure or judicial foreclosure. You can do them in tandem, and then you can make your election of remedies later if you deem it appropriate. You may want to do the judicial foreclosure so you can get a receiver appointed, take control of the project, and see what you can do to try and liquidate it or get it moving. As I mentioned, you can do concurrent non-judicial and judicial foreclosures, and those benefits are the ability to use court process. When you do get to the sale, take in consideration credit bid risks. If you do what's called a full credit bid, which is your entire loan balance, which we wholeheartedly do not recommend, you risk losing title insurance coverage, you risk losing other insurance coverage against the property. That is the subject of another webinar, numerous articles. When you do the foreclosure sale, you just need to make sure that you do everything properly, dot your I's, cross your T's, make sure everyone's been given the required notice, and that there's no bid chilling or anything like that, because you want to avoid any attacks on the sale. John, do you have any concluding remarks?
A couple of comments. First, if you want the PowerPoint deck, which we did on mortgage lending in the shadow of COVID-19, please send an email to Martha Pineda. That's Pineda, MPINEDA @buckhalter.com. Our next webcast would be Buy and Selling Real Estate in the Shadow of COVID-19. Thank you for participating with us today.